Welcome everybody to this great Thursday afternoon. We're joined here with me. I'm Dave Etkin from the Louisville Small Business Development Center. We've got some great guests today. Before we get going, I'd like to speak a little bit about the Louisville Small Business Development Center. We're part of the Kentucky Small Business Development Centers. We are the only statewide nationally accredited program that provides entrepreneurial and business development services. We play a vital role in the Commonwealth's economic development by assisting entrepreneurs at every stage of the business life cycle. For almost 40 years, Kentucky SBDC has assisted emerging and growing businesses by providing professional expertise, tools, and information necessary to make sound business decisions in the complex and ever-changing market space. We do this at no cost with our clients, thanks to the U.S. Small Business Administration, who co-sponsors our program, which is then administered by the University of Kentucky, who partners with regional universities, colleges, and local economic development agencies. We're part of a national network, America's SBDC, with over 1,000 centers across the nation. To learn more, visit kybizhelp.com. There you'll find additional resources to help start, fund, and grow your business. To request personal assistance, email at info@kybizhelp.com or call 1-888-475-7232. And a recording of today's webinar will be emailed to you later this afternoon. If you'd like to get in touch with us here at the Louisville Small Business Development Center, check us out at louisvillesmallbusiness.com. And as we plan to do quite often in the future, we're joined and doing this, we're co-sponsored with the Kentuckiana Hispanic Business Council, and I have Yamika Rodriguez and Ben Rees, both board members on the council. And so, Yamika, why don't you tell us a little bit about the HBIC?
Yeah, so thank you, David. Thank you so much. We're very honored and excited with the partnership. And here at KIHBC, it's Kentuckiana Hispanic Business Council. So we do serve Louisville and Indiana, or Kentucky and Indiana. And we are really here for our small businesses as well, Hispanic small businesses. So we serve them, and that's the reason why I love this partnership. So we are here to really help any small business that needs our help, that either that speaks Spanish or even speaks English. We're here to really help your business grow. And so we are hoping to have more partnerships with you and in the future on helping people with their business. Thank you.
Well, Ben?
Thank you. Yeah, we're very excited to have this new group that has been working for over 2 years now. There's a dozen outstanding Hispanic leaders. I really feel honored to be part of them because, you know, we have, for instance, Gladys Lopez, who's the head legal counsel at Norton Healthcare. Then we have Alex Alvarez, who's the executive VP at Brown Forman. We have David Lopez, who works at Metro United Way, just to mention a few. And then we have Rick Zamora, who's with the Wade Houston Group. And Eleazar Puentes, who's a businessman like I am. And then, of course, there's Yamilka, who's one of our beautiful leaders. And we are excited that we're going to be offering these kind of webinars on different subjects. Today, the subject is bancarrota in Spanish, which is bankruptcy, how to avoid it during the pandemic. So thank you for letting us present this. And if you have any questions, there'll be a poll at the end of this. So thank you very much, David.
Yes. So again, as Ben said, if you have any questions, if you look at the bottom of your screen, there's a Q&A button. Just click that, and you can kind of type some Q&A in there. And you might want to just check that out and just introduce yourself and tell us where you're from. And we'll go ahead and get started. We have a great guest today, James Irving, who's a great friend of mine. I've had the opportunity to really get to know Jim and spend a lot of time with him. He is one of the smartest people I know, and I really look up to him. But there's some new things that have changed in bankruptcy law as a result of the CARES Act, and I think it's a great opportunity for small businesses to use some of these new tools. So we thought we should get Jim back on board and get him to spend a couple minutes with us this afternoon so we can kind of understand the new laws and how they can help small businesses. So Jim, introduce yourself and tell us a little bit about you, and let's get started.
Yeah, thank you so much, Dave. It's a very kind introduction, and I'm really happy to be here to the group and to help talk with people about bankruptcy restructuring options, especially during this really unprecedented time. So thank you for having me here. And also let me say, this is one of those areas where I believe in restructuring and believe in it as actually a very positive, forward-looking practice because it's taking a difficult situation and trying to make the best out of it for creditors and for businesses and for the people involved as well. I am a partner at Dentons, Bingham, Greenbaum. It's part of the Dentons law firm, which is the world's largest law firm with over 8,000 lawyers. It also has the most comprehensive Latin American footprint of any law firm that is worldwide. So we've got offices across South America, Central America, and the Caribbean. Just this week, we introduced that we're opening a new office in Medellin, but we also have offices, throughout South America, in whether it's Santiago or Caracas, Mexico City, Panama City, etc. What I'm going to talk about today, though, is the United States Bankruptcy Code and restructuring options under U.S. law, and specifically some new changes that took place this year. CARES Act, which many small business owners paid a lot of attention to because they were looking at it for PPP loans. But it also impacted a new law that was passed last year and went effective in 2020, which allowed for a more expedited reorganization of small businesses called Subchapter V of Chapter 11. So with that, I'm going to launch this presentation. And we'll begin. Again, Jim Irving, I'm at Dentons. My contact information is here if anyone has questions. I'd love to have a question and answer session at the end, but sometimes people will have kind of one-off or individual questions that they may want to ask during the presentation. So overview, what are we going to talk about today? We're going to talk about the types of debt and negotiating with creditors. I think that's something most business owners are familiar with, but the type of debt, whether it's secured or unsecured, and the legal priority they may have is a critical issue in any restructuring. We'll talk briefly about force majeure clauses. That's technically an issue that expands well beyond bankruptcy, but it's hot right now, and I think that it merits attention and some discussion. Then I'll talk about the chapters of the Bankruptcy Code available to businesses, and particularly small businesses. Chapter 7, which is a liquidation. Chapter 11, which is traditionally known as a reorganization. And the new Chapter 11, Subchapter Roman numeral 5, Subchapter 5. We'll talk about some strategies and timelines within these parts of the Bankruptcy Code, and then have time for question and answers as well. One thing that I'd want to make clear at the beginning as well, though, is when we talk about the larger topic of restructuring a business, today's going to focus on bankruptcy options, but there are also other options for a business as well. Sometimes it's just shutting down the business and dissolving under state law. It could be a business or an entity is put into a receivership in state or federal court. Could mean a foreclosure. There are other options available aside from just bankruptcy, but because of the limits of time and to really dive into a subject, today we're going to talk primarily about the Bankruptcy Code. So first things first, to understand any of the different chapters of the Bankruptcy Code or our discussions today, we need to lay a basis to talk about the different types of debt that a business has. And here I've categorized them three major ways. Secured creditors. that is a creditor that has a lien or a mortgage on assets of a business and then entitles the creditor to payment from the proceeds of that asset for other creditors. In most traditional sense, a bank holds a mortgage on your home. It is a secured creditor, and its collateral is your house. In a business context, that typically means a bank or some other lender has a line of credit that is extended to the business, and typically it will be secured by a lien on substantially all of the business's assets. So typically we're talking about lenders, but it can mean an equipment vendor as well. If you're renting a forklift, there's a chance that the financing for the forklift, that the person that sold it to you might have a lien on that particular forklift or other piece of equipment. And it can also mean a purchase money security interest. That means you bought something from a vendor and the vendor is asserting a lien on the assets it sold to you. A final type of item is a mechanic's lien claimant or a warehouseman. That's an issue where you have a contractor or a worker who repairs a piece of equipment, improves your real estate by fixing your roof, and they can assert a lien on the real estate until the invoice for their roof repairs are paid off. So there are multiple types of secured creditors, but in all instances, they're a creditor that has a first right of payment from the proceeds of a particular asset of the business. And of course, there can be priorities among these secured creditors, normally by whoever is first to file, or what's agreed upon between the creditors under something called an inter-creditor agreement. So the bank might be first, and a second mortgage, would be second. Unsecured creditors. Well, an unsecured creditor is just a creditor that doesn't have a lien on assets, doesn't have a mortgage. Now, that's your typical trade vendor. That's your taxes until the IRS or someone else puts a lien on your property. That's any of your other vendors. That's typically your landlord until they assert some kind of a landlord lien. We're going to talk about different categorizations of those unsecured creditors as well. In a bankruptcy context, we'll talk about administrative claims. Those are first in priority in a bankruptcy case among the unsecured creditors and largely relate to the cost of administering a bankruptcy case. That means attorney's fees, that means trustees' fees, but that also means all post-bankruptcy expenses in a Chapter 11 case. We'll get to that later, but imagine the idea of before you file your bankruptcy petition, all of your unsecured creditors are paid one way. And then after the filing of the bankruptcy petition, the cost that you need to operate and preserve the business in bankruptcy having special priority. After administrative claims, there are general priority claims. Those are claims that have a special statutory priority established by Congress. Employee wage claims capped at $13,650 per employee, unpaid taxes, and other items that the Congress thinks have priority above normal trade creditors. And then your normal trade creditors, your vendors, your landlords, those are general unsecured claims. Finally, in the bankruptcy context, equity interests, your ownership in your own business would be the last type of claim or interest and normally have the lowest priority. Creditors would be paid before you would recover anything from the business in a bankruptcy. So before bankruptcy, there's the general idea of, well, can I avoid this? Can I negotiate with my creditors? And generally, I would advise any prospective client to try that first because of the risks and costs associated with a bankruptcy case. Negotiating with creditors outside of bankruptcy can be much more cost effective. You're also not interrupting your business. Even though a company can survive quite well in a Chapter 11, and I find that there's not nearly the stigma of bankruptcy that there was 15 or 20 years ago. now so many entities that people do business with every day have filed for bankruptcy, sometimes multiple times. If you go to a mall, any mall, and you walk through, you can name the number of entities that have filed for bankruptcy or come out of bankruptcy or have been close to it. Part of that is because of what's happening in the retail industry now, but it also normalizes the concept of bankruptcy. But there's no stigma, there's no interruption, your attorney's fees are lower. And if a business can strike a deal with its creditors and survive without bankruptcy as an option, I would always recommend it. But there are limitations to what negotiation can accomplish. If creditors are unwilling to accept less or to be paid over time, then the business has to have the money available. And if the business doesn't have the money available, it doesn't have many options. Creditors can start trying to seize assets. Creditors can commence litigation, lawsuits to collect on the amounts owed. Just negotiations aren't going to be able to stop those. There's also not a third party to go to when there are disputes with creditors and just normal negotiations. Creditors are going to have to consent to any deal voluntarily. And frequently with businesses, this is true for both large and small businesses, it can be very unwieldy to negotiate with lots of different creditors. Represented a steel company a few years ago with 30 or 40 different creditors, which isn't terribly unusual, different vendors. And it's herding cats to a certain extent. What deal you're able to negotiate with each one, there are only so many hours in a day to do that. There are very finite resources. And if all of the creditors didn't consent, if just one of them forced litigation, tried to get a judgment, tried to undermine or sweep the bank accounts of the business, it would all be for naught. Bankruptcy provides a solution to those problems, but comes with its own risks and nuances that we'll talk about later. One thing I wanted to talk about too, this has come up quite a bit this year, clients have asked me about it, is the notion of force majeure, especially when negotiating with creditors. So some of you have probably heard of force majeure. You may have come up with a lease, supply agreement, some other obligation you have to another party. And somebody said, well, hey, have you considered a force majeure option to get out of your obligations? Generally, force majeure means that if a party to a contract does not perform its obligations under the contract, it's going to be liable for damages. But parties can allocate the risk of performance if there's some force beyond their control that would allow them to be excused from performance. Black's Law Dictionary defines it as a contractual provision allocating the risk of loss if performance becomes impossible or impracticable. What I think of is, the classic scenario is there's a ship at sea, there's a hurricane, it's sunk. Force majeure might look to the hurricane essentially like an act of God for excusing the company that was trying to ship its products from point A to point B for them not getting to point B because a hurricane sunk the ship that the products were on. Classic force majeure type scenario. But under Kentucky law, if there's not a force majeure provision in your relevant agreement, it's going to be very difficult to rely upon it. There's a case law site here, but the only way is if it was just impossible to comply, and that doctrine is very strictly construed. Generally doesn't allow for non-performance unless it's in the contract. So to summarize generally, force majeure would allow you to get away from payment if there's such a clause in your contract. You need to look specifically at that contract. If you don't have a force majeure clause in a contract, it'll be hard to get away from it. Let's apply that to COVID, the pandemic, and the related recession. If, for example, you're a small business, let's say you're a restaurant, you're having difficulty paying your rent, You might want to leave the location. You might want to downsize what you have. You look in your rental agreement, your lease, and you look for, is there a force majeure provision in here? Where because of the pandemic, because of the stay-in-place orders, because of something else that I'd be able to grab onto to allow me to exit my lease without having to pay the full amount owed. That, for almost all small businesses, is going to be a really important issue to look at when they're figuring out what debts they owe and in any negotiations. So with that little bit of a detour, let's go back to bankruptcy. So now presume that negotiations with creditors haven't been successful. You looked at other options, whether that's consenting to receivership or foreclosure, and determined that bankruptcy is the appropriate option. Well, what types of bankruptcy are there? There's Chapter 7, which is the liquidation of a business, and Chapter 11, which is reorganization. Today, we'll talk about both of those, but we're especially going to focus on new small business or Subchapter 5 reorganization. Originally, those were for companies that had debts of less than $2.725 million, but because of the CARES Act, the same law that allowed for the PPP loans that many of you likely took, the debt limit has been raised to $7.5 million. And this new small business reorganization, not only may it apply to most of the people that are listening today and their businesses, but the concept is that it will provide the advantages of reorganization at costs and expenses and with a speed that's more akin to a Chapter 7 liquidation. So, Chapter 7 liquidation, what does it mean to file for bankruptcy? I have thought it's funny. There's the old TV show, The Office. There's a character in it, the manager, Scott, and he doesn't have enough money. And he walks out into the room and he says, "I declare bankruptcy," like in a game of Monopoly or something. And that's not what bankruptcy is. But because it is a topic that many successful entrepreneurs don't want to get into, I think it makes sense to talk about what does it mean. So in a Chapter 7 case, that's a liquidation. A debtor, that's the business that owes the debt, files a voluntary petition for relief under Chapter 7 with a bankruptcy court. A trustee is appointed to identify and liquidate the debtor's business. The trustee is frequently a lawyer, sometimes it's an accountant, sometimes it's someone else. And trustees almost always come from a panel of trustees who see various cases, and that panel is maintained by the Office of the United States Trustee, which is part of the Department of Justice. So the debtor and its principals, they cooperate. They turn over assets and control of the business. They provide information to the Chapter 7 trustee. They disclose everything that the debtor owned, everything that it owes, prior payments, and they testify at a meeting of creditors, which is held not with a judge, but normally at a federal courthouse. Sometimes they're telephonic or via Zoom during the pandemic. And they go through and they explain what led the business to its current state and what assets it has, who's owed money. The trustee is going to look at what's available, sell property. He may pursue litigation. Those are both causes of action that the debtor has. So say the debtor has lots of accounts receivable. One of its customers hasn't been paying yet. It's what led to the bankruptcy case. It might sue to collect on those accounts receivable. Chapter 7 trustee may also pursue what's called preference claims or avoidance action claims. That means payments that the debtor made during the 90 days before the bankruptcy case that allowed a creditor to receive more than they otherwise would have. It's a preference. Those might be pursued. A Chapter 7 trustee might also look at a debtor's officers, directors, insiders, principals, and see if they received more than they should have, or if they received money, payment, goods when the company was insolvent. Creditors, are going to be able to file claims, and they will be paid according to the priority that we discussed earlier. Secured creditors are paid first out of their collateral, the proceeds thereof. Unsecured creditors, administrative claims, that's the trustee, other costs of administering the estate are paid first, and priority claims, wages, taxes, and then general unsecured creditors. And each class of creditor is paid pro rata, so evenly. So if all of the vendors, all of the general unsecured creditors, they're all going to get the same 15 cents on the dollar. One unsecured creditor is not going to make more than another unsecured creditor if they're in the same class. Equality of distribution is one of the principles of the bankruptcy code. So that's liquidation. It is basically, I'm done with the business, let's wrap it up. But for many on the phone, what they'll recognize is, I have a business, I think there's value in the business. We could pay creditors more, but I need to get through this patch. I need to get past this problem that we found ourselves in because of COVID or because of some other factor. There's fundamental strength here. And that's available under Chapter 11. So Chapter 11, Reorganization. Now, I'm going to read this out because I think these are important principles. So Congress established Chapter 11, 1978, with the idea of creating a system for business reorganization and providing businesses with a second chance. The goal is to allow businesses with fundamental strength or employees or assets to reorganize for future success without just destroying the business. And the goal, as the Supreme Court has noted, is balancing a debtor's interest in that reorganization against a creditor's interest in maximizing the value of the bankruptcy estate. So how am I going to preserve value while still maximizing creditor recovery? So let's talk about the timeline of a Chapter 11 case, and that'll lay out a bit about what you could expect and how you actually preserve a business and maximize creditor recovery. So on the first day of a case, you file a Chapter 11 petition on a Chapter 7. A trustee is not automatically appointed. Rather, in Chapter 11, the debtor, as a default, remains in possession of the business. And the debtor, the management of the debtor, continues to operate its business in the ordinary course, but has to go to the bankruptcy court to seek authorization for certain special transactions outside the ordinary course. What's more is, because creditors might want to take actions against you, or there's certain things that you need to do that are immediately outside the ordinary course, a debtor will typically file a number of motions with its bankruptcy petition and seek an immediate hearing from the court to allow it to continue acting in a certain way. A typical example are, you're going to want to file a motion to make sure that your utility companies don't cut off service. You'll want to file a motion to ensure that you can pay your employees who have pre-bankruptcy claims, which normally could only be paid by court order. You're going to want to immediately pay them in arrears, or otherwise all your employees are going to quit. So you would have a first day hearing in the case. Then that'll be on just an interim basis to allow that relief, with typically final approval of that interim relief a few weeks later. During this early stage of the case, Chapter 11 debtors often make initial operational changes. You've got to immediately think, okay, where can we cut expenses? What can we do to maximize that, receivables, income? Are there aspects of the business that are just not making sense that we should shut down now? Should we consider a sale of substantially all of our assets or a particular part of our business? It may be a change in management, where existing management leaves and you either hire a new professional manager in a bankruptcy case, sometimes called a chief restructuring officer, or you decide that you're going to get rid of some vice president and, promote someone else. There may be a creditors committee. And what Congress created in 1978 was they recognized that creditors, especially unsecured creditors, not your bank, but your vendors, they may have many claims that are mid-size, but they're not sure how much they're going to recover on it. It's not economical for them to hire counsel to appear at everything in the case, but they are the fulcrum. They're the center constituency in the case. You might have more trade vendors or unsecured claims than your bank is owed or anyone else is owed. So to recognize and represent their interests, Congress said that the U.S. Trustee's Office, that's the same part of the Department of Justice that administers the appointment of trustees in Chapter 7, that they should appoint an official committee of unsecured creditors, and that those creditors would advocate for the interests of all the unsecured creditors in the case, not just their committee members. They're allowed to hire counsel, and their counsel has to be paid for by the debtor. So you're paying for your lawyer, and you're paying for the committee lawyer. You're also paying fees to the United States trustee for the U.S. trustee's lawyer. Not directly, those fees are calculated based on revenue, but essentially you've got 3 significant costs for Chapter 11 already. And I want you to keep that in mind as we later talk about Subchapter 5. After committee's formed, there's going to be negotiation about what's happening in the case, how a company's going to reorganize, whether, again, that's a sale of the assets, whether that's a plan of reorganization. We'll talk about those later. Negotiations will go on. Initially, there's a 120-day period to determine what you're going to do about your leases, what you're going to do about filing a plan, and ultimately, the goal of any Chapter 11 case is to get to a plan of reorganization, which will set forth everything that you own, everything that you owe, and how you're going to use what you own to pay what you owe and preserve the going concern of the business. Major points of Chapter 11. And again, we don't have a lot of time, so I'm just going to hit some high points. In any bankruptcy case, one of the biggest advantages is the automatic stay. That means that immediately upon filing for bankruptcy, no one can sue you anymore. Any lawsuit that's already pending is stayed. And no one can send you demanding or threatening letters anymore, dunning letters. Why haven't you paid me this? Finally, they can't terminate a contract with you just because you filed for bankruptcy. If a creditor or a contract counterparty wants to do any of these things with a debtor, they have to go to the bankruptcy court and demonstrate that there's cause to modify the automatic stay to allow them to do this. And just because you're a debtor, that's not cause. Cause might be that you acted in bad faith in some way, that a secured creditor like a bank is not adequately protected, that the value of its collateral is diminishing and it's just being forced to sit on the sideline, or that you're never going to be able to reorganize. And it's unusual for a party to have relief from the automatic stay granted during the first initial stages of a bankruptcy case, the first month or two. Cash collateral, debtor in possession financing. One of the major problems for businesses that I advise, especially now with COVID issues, when they come into bankruptcy case, they're running out of cash, right? I mean, fundamentally, you're in bankruptcy because you owe more than you're able to pay. But your cash is probably the collateral of one of your lenders. And in order to use their collateral, you need to have court authority. So the cash is the collateral of the lender. You need to have an order authorizing the use of cash collateral. You may even need to borrow more money to fund your restructuring. You are a debtor in possession. We talked about that before, Chapter 11. You remain in possession. That's called DIP financing. DIP is debtor in possession financing. So essentially, this is going to be a key issue in any case, figuring out what cash you have, including proceeds, whether you need financing, and then getting that approved by the bankruptcy court. There's heavy negotiation on this point, and there will almost certainly be a budget which will set forth what the debtor can spend and on what, with projections going forward, normally for 13 weeks. One item that I know, especially for those who aren't familiar with bankruptcy, they'd say, why would anyone lend money to a debtor in a bankruptcy case? It just seems nonsensical, right? Well, debtor in possession financing, a lender who provides debtor in possession financing can get advantages in the order authorizing it, super priority status, so that it's paid off first. In certain instances, it can get a priming lien, so it has a lien on all the assets above the other creditors. It can be a scenario as well, very typical, where a bank realizes, I am lending to, I'm going to use an example of a factory. I'm lending to a factory. The factory's having difficulty now because of COVID and supply chain disruption. On a long-term basis, I think that if they can run a sale and marketing process, I could get paid out in full from the sale of the business as a going concern next spring. But they don't have the money to pay payroll now. They're going to close. I'm going to foreclose on my assets. And what's going to end up happening is I'm going to get 50%, 50 cents on the dollar from selling a bunch of used equipment and an empty factory building that nobody else wants. So rather than taking a 50% loss as the bank, I'm going to lend this debtor who was already in arrears to me, who was already not making payments to me. I'm going to lend them more money, but I'm going to require that they do that in a bankruptcy case, and I'm going to tie their hands up to say, I get paid first, I have a lien on everything, and you're going to meet these milestones to sell the business. And ultimately, if I don't like the buyers that come here, I can credit bid, I can bid the debt to purchase the factory myself, and I'll hold on to it and I'll sell it for who I want. So those are instances where you might want to have debtor in possession financing, and those are the advantages of why someone might lend a debtor in a bankruptcy case money. Executory contracts and unexpired leases. One of the most powerful sections of the Bankruptcy Code is Section 365. And what it allows a debtor to do is to choose which contracts that are currently ongoing contracts with obligations due and owing on both sides. Those are called executory. Classic examples like a lease or a supply agreement where for the next 6 months, the factory has to provide 10,000 widgets and the buyer has to pay $100,000 for the widgets each month. Ongoing obligation. The Bankruptcy Code allows a debtor in possession to choose to assume those contracts, continue to fulfill their obligations, to assume those contracts and sell them to a third-party buyer, in most instances without the consent of the non-debtor counterparty, or to reject the contract itself. The counterparty would have a general unsecured claim, but the new debtor could go on and live and survive going forward. Essentially what this does is it gives businesses with fundamental strength the ability to get out of a bad deal that is an albatross around their necks and to move forward. A few notes on executory contracts. If a contract's assumed, you have to cure all defaults. So you have to pay in full for it. And you've got to prove that you're going to be able to perform going forward. There are special rules for non-residential real estate leases. So if I'm a landlord, I file for bankruptcy, I feel like I've got an under market tenant, I want to reject their contract. The tenant in a non-residential real estate lease has the right to remain in possession. Equipment leases and intellectual property leases have specific issues. There are anti-assignment or consent to assignment clauses. Those are generally not enforceable in bankruptcy. subject to certain exceptions that if you ever find yourself in this instance, your lawyer can talk to you about your specifics. There's also a special rule for personal service contracts, and this comes up a lot in small businesses. So you've got a critical employee who's under contract for 2 years. The employee doesn't want to work for the new person. You can't make a human work for someone else. That is violative of the 13th Amendment against slavery. So you can't make a person continue to work for you. You might have a cause of action against them. You might be able to sue them for money, but they don't have to work. They might have to pay you, but no one's going to show up with a gun to their head. So we talked about, you've got the advantage of the automatic stay. You figured out your cash use, either with debtor possession financing or the bank has allowed you to continue to use your existing cash and receipts. You've figured out what contract you want to keep, assume, assign. The ultimate goal of your case is to confirm a plan. Now, you might sell substantially all of your assets first and seek authority from the court. You might sell some assets, but eventually you're going to want to get to a plan. Especially if, as many of you on this call, I would imagine, entrepreneurs started the business, you have a lot invested both financially but also personally. And you want to stay committed to running that business. And frankly, there's nobody else that's going to be able to run the restaurant, the clothing company, the factory, whatever it is, as well as you, the entrepreneur who started it, can. So, plan of reorganization. Plans are complicated. Frequently lengthy documents that are accompanied by a disclosure statement. The plan and the disclosure statement have to be approved by the court. The disclosure statement on a preliminary basis to show that it adequately describes your plan. That's sent out to all of your creditors, and your creditors have to vote to approve the plan. For each category of debt, we're going to go back to our first point, there'll be a class of creditors. And for a class to approve a plan, at least 2/3 of the dollar amount of the voting creditors and more than 1/2 of the number of claims voted have to vote yes. So, for example, let's say we're talking about unsecured creditors. You have $100,000 in unsecured debt, which is voted on in the plan. You need to make sure that the votes for yes represent at least $67,000 in the aggregate value of the votes of the debt, and say the $100,000 is divided by 100 creditors. You need 51 of the voting creditors to vote yes. Not all classes of creditors have to vote yes to confirm a plan. You have to have one class of impaired accepting creditors. So one category of creditors, one class, is getting less than they otherwise would have. They're not getting 100 cents on the dollar. And they say, yes, I approve this plan. And then you have to follow something called the absolute priority rule to make sure that you're following the priority scheme talked about in the bankruptcy code that we discussed earlier. Secured creditors are getting paid first as to their collateral. Then priority claims have to be paid in full as of confirmation. Administrative claims in full as of confirmation. Then general unsecured creditors are getting paid. They're getting paid at least as much as they are in a liquidation, or they're voting to accept the plan. The equity, the ownership of the company, if equity is riding through, you either have to have everyone consent, or you need to make a new equity contribution. You have to essentially buy back your ownership in the business. And it has to be the best plan. There can't be somebody who's willing to pay more. So, for example, I'm going to use the factory again. Say you don't do a sale with the factory, you're doing a plan of reorganization, and there's somebody that wants to buy ownership and is willing to pay the creditors 50 cents on the dollar, but you're the existing owner, you're only able to pay 40 cents on the dollar. The ownership of the company could go to the person that's willing to pay more for the equity ownership in the new company, pay more to the creditors. If creditors are not accepting, you can cram them down by showing that your plan is fair and equitable. There's not someone willing to pay more. Cram down, that is a specific term under the code and case law. But cram down is really hard. It is very difficult because you've got to show that it's fair and equitable, that someone's getting more than they otherwise would have, that you're following the absolute priority rule, etc. So when we talked about Chapter 11, there are a lot of steps. You're paying your counsel, you're paying a committee counsel if a committee is formed, you're paying U.S. trustee fees, which are a percentage of your gross distributions, a few percentage, but remember, you're already cash crunched. You're using either just your current cash receipts, or perhaps you borrowed money, debtor in possession financing. And the saying goes, that's expensive money. You probably got a high interest rate, you probably got some decent fees. So Chapter 11 is a very expensive option, especially for a business that already had some kind of a weakness. Either you didn't have enough operating cash, or you had debts that far exceeded the value of your assets. So Congress, recognizing how expensive Chapter 11 is, and how time-consuming it can be, last year sought to reform it with a new Subchapter 5 for small businesses. And to qualify as a small business, the debtor needs to be a person who's engaged in commercial or business activity. So if it's just credit card debt or personal expenses, that's an entirely different conversation to talk about with potential something called Chapter 13 or Chapter 7 or an individual Chapter 11. This is business debt. Or a business organization, an LLC corporation, engaged in business activity with $7.5 million in debt or less. An important note, Dave has heard this presentation before, but one that I wanted to point out. Courts have started construing that as $7.5 million in liquidated, non-contingent debt. What do I mean by liquidated? I mean, you know the amount and you don't dispute that you owe it. It's not riding on some other factor. Some of you watch the news. 2020 has been a parade of horribles, but one of the horrible things that happened was there was a dam failure in Midland, Michigan, that flooded large parts of the city. The dam filed a Subchapter 5 bankruptcy case because it's undisputed, liquidated, non-contingent claims were less than $7.5 million. Now, they also faced $80 million in lawsuits from the failure of the dam, but they still qualified for Subchapter 5. The only type of business which is excluded from Subchapter 5 is something called a single asset real estate entity. That is like an LLC or some other business that owns just dirt or buildings or real estate and derives its business from the dirt, buildings, or real estate. Classic example is the strip mall limited liability company, right? They own the strip mall, the parking lot, they get rents, that's all they do. If you're actually making something, you're providing a service, you're more than just a single location, you're not a single asset real estate debtor. The goal of Subchapter 5, make it faster, make it less expensive, and I think implicitly make it more likely that small businesses are going to be able to reorganize as opposed to just get liquidated. Because Chapter 11 has become more and more geared toward what in DC or New York, you probably could say the mid-sized to large company, but would be considered a very large company here. So we're talking debts of probably at least 25 million to a couple $1 billion. Not what most people think of when they think of small business. This is to help the mom and pop operation, the restaurant, the local business. So differences. there is a small business trustee who is appointed. The small business trustee is not at all like the Chapter 7 trustee who's going to come in and liquidate the business. The small business trustee's goal is to act as almost a third-party neutral to facilitate the development of a consensual plan of reorganization. So they're going to step in and, say the bank is angry because they have not been paid for the last several years. The small business trustee is going to step in and say, okay, bank, you need to be realistic about what you're going to recover here. The small business trustee is authorized to operate the debtor's business if the debtor is removed as a debtor in possession, but more likely they're going to be kind of a wingman and a guide to the debtor. There's no creditors committee, so you're not going to have to pay for committee counsel. There's a faster timeline. By statute, within 60 days, there has to be a status conference in the case to discuss the further expeditious and economic resolution of the case. 14 days before that, the debtor has to file a status report detailing its efforts to attain a consensual plan of reorganization. So if you've got to file a status report about 45 days into the case on getting a plan done, you're going to need to start moving on that immediately. The deadline can be extended, but you have to file a plan within 90 days of the commencement of the case. That's much faster than most Chapter 11 timelines. So I'll talk with some experience. Right now, I represent Gincana. You might know Gincana. It was even in a political campaign ad and in our Senate race, but it's one of the country's largest hemp to CBD companies. So I represent it as debtor's counsel. We commenced the case on February 5th of this year. We have a confirmation hearing to confirm our plan of liquidation on November 9th. I would consider that fast in the typical Chapter 11 context. You can see that as much longer than the 90 days between the commencement of the case and the filing of a plan that's contemplated under Subchapter 5. Only the debtor is allowed to propose a plan. So under Chapter 11, normally only a debtor is allowed to propose a plan for the first 120 days, and then after that, unless that period is extended, anybody can propose a plan. Subchapter 5, it's the debtors, unless there's a court order. Requirements to confirm a plan, they're the same except for some pretty big differences. You do not need to obtain the acceptance of an impaired accepting class of creditors. So in a normal Chapter 11 case, you've got to figure out, like, okay, where are my allies? What creditor body is going to support what I'm trying to do? You don't have to have an impaired accepting class. One of the other things you're concerned about in Chapter 11 is you've got to pay all of your administrative claims, your priority claims, on the barrelhead at confirmation. Under Subchapter 5, you can pay those over time. You can string that out. And you can still cram down a secured creditor, but equity holders can retain interest in the business even if the plan does not pay unsecured creditors in full, as long as it does not discriminate unfairly. Essentially, this makes it much more likely that existing ownership is going to be able to keep control of the business and successfully reorganize without a secured creditor or another creditor body putting a gun to their head and saying, no, I'm paid in full, or this plan's never working and this business is liquidated. So that's the formal presentation, right? I want to thank everyone for going through that. I said a lot. I know I saw at least one question here, and would love to do some just general question and answer if you'd like. We've got about 9 minutes left. I wanted to leave 10 minutes left, so I was pretty close on time.
Thanks, Jim. That was great, as always. That's such a great tool now that they've kind of changed that a little bit, made it a little bit easier. It's quite encouraging. But so, someone who wants to remain anonymous asks, I own a catering business. Our catering contract cancellation or failure to pay is 11 or more business days prior to the event, caterer shall retain 50% of the deposit, 25% of the total fee as liquidated damages. We have a force majeure statement in our contract. If a client decides to cancel their event because of COVID, instead of rescheduling it for a later date, can they use force majeure to try to get the whole deposit back?
Maybe. I think that they probably would have had a better argument for that earlier in the year, and that's probably less likely now. The specific language matters a lot, and the particular facts matter a lot as well. So I'll use my own life as an example. My son's birthday was March 14th. He's a second grader. There was another kid at his school who was his same age, who was one of the first 2 Jefferson County children who had COVID back in March.
Mm-hmm. Wow.
Yeah, I know, right? Everyone's fine. But we ended up canceling the birthday party, right? It was going to be on the 14th. That was right around when people started doing the lockdown and shutdown. I think we could have had an argument for force majeure, technically, with what was going on with the governor's orders. It was at the beginning of the process. We ended up just paying the deposit to the business. But there could be, in that instance, you really need to look at the specifics of the contract and the specific facts. Now, I understand that we have a spike in cases, but there are a number of businesses that are back in person or that are operating. Things are a little bit more foreseeable. You've got to consider when the contract was entered into. I mean, if somebody entered into a catering agreement in August and they're trying to get out of it in October, and you don't have, a healthy home order. I know they didn't want to say stay in place, but whatever it is, you don't have an order like that.
Yeah.
I think that it's harder to argue force majeure than it would have been in my March example, but where that was booked back in December, January, where it was just a Wuhan, China thing. But fact intensive. Happy to talk about it later if you want to give me a call. And my info's there.
Nice. So let's see. Looks like we have another question here. If an individual owns multiple businesses or partnerships, can he file bankruptcy on only one of the businesses, or will he have to file bankruptcy as an individual?
That's a great question, and it raises a really important issue. So businesses are separate entities from the individual, and they're separate entities from each other. As a general statement, if you are Dave Etkin, let's pretend Dave owns 3 different businesses. 2 of the businesses are doing great. One of them is not doing well. He can file just the one business that is not doing well. And unless there's a reason that the debts and liabilities of that one business that's in bankruptcy would relate back to Dave or his other businesses, the creditors of that one entity won't be able to pursue Dave or the other businesses. So the immediate question becomes then, what instances would allow the creditor of the failing business to pursue the successful businesses or its principal? Personal guarantees. Typically, if you borrow money from a bank, if you are a small company, the bank may require you to sign a personal guarantee where you say, if the company doesn't pay, I will personally pay. That's the most likely instance. The second instance, sometimes when people own multiple small businesses, I'm representing some companies in Southern Indiana, they have multiple loans with the 2 kind of related small businesses. And they've not just guaranteed each other, but they've done something called cross-collateralization, where one bank gave 2 loans to 2 separate businesses. But the loan document provides that if I foreclose on business A and I take its real estate, and that's not enough to pay off loans, I get to look to the equipment or receivables or whatever else business B has. So related. Those are contractual ways you could trace back. The third is non-contractual, where the business in the individual and the separate businesses never observed corporate formality, and they acted like they were all one entity. I represented a creditors committee, unsecured creditors, and there was a family business that was up in Indianapolis based, and they had locations throughout the Midwest, and they sold tires, and they pay personal credit cards, they're paying the owner's expenses all the time, and the businesses, you know, one tire location might be paying some other tire location's business, and technically they're all different LLCs, but they had merged all their accounting system into one Quicken book, and there they were all the alter ego of one another. The corporate veil between the different entities just pierced through, so that they were all liable for one another's debts. It just wasn't a real distinction. But there's another question you didn't ask that I'm frequently asked, especially by small business owners. If I own a small business, I own a restaurant, and it files for bankruptcy, is that going to impact my credit score or my ability to get a loan and start another business? Because I'm entrepreneurial in my blood. I want to start another business, but you know, Jim Irving's hot dog heaven isn't working. It will not, or it should not, impact your credit score. Credit scores are built by primarily three large entities that, you know, TransUnion, Experian, et cetera, that put those together in those instances when you're applying for a home mortgage. But if you're filling out a loan application, if you're going down the street to Republic Bank or PNC or anybody else, it's quite possible that their loan application will say, like, are you a principal of business that's ever filed for bankruptcy before? And you should always tell the truth on loan applications. Lying under loan applications has serious criminal implications, and you would need a different kind of lawyer. So yeah, come up in questionnaires in the future, but it probably won't impact your credit score.
Yeah. Good answer. Looks like all the questions we have. I do have one kind of question / comment, Jim. So really the goal of this type of bankruptcy is not so much liquidation to go away, but this is a way to give a business owner some breathing room to live, to fight another day. Is that a fair statement?
Absolutely. That is the takeaway. Subchapter 5 is about recognizing there's a business that has value, that there's something good there that can be preserved. And in fact, you're going to be able to pay creditors more if you can preserve that. But because of what's going on in the world, because of difficult creditors, you need protection from the automatic stay. You need some power to get rid of contracts, you know, redo your books, make some changes, and come out stronger and better for it. So that's the goal. That's what Chapter 11's goal is as well. But you know, General Motors came out of its bankruptcy a lot stronger than it went into it, but it spent tens of millions of dollars in professional fees. Mm-hmm. That's not realistic for the small business owner. Subchapter 5, the goal is to make this more affordable for the small business owner.
Great. Well, it looks like we're at the top of the hour, so I gotta be mindful of your time, Jim. I really appreciate you sharing again. I mean, this is such an important subject, especially this day and age. So I want to thank you again for coming, and thanks to the Hispanic and Kentuckiana Hispanic Business Council with Ben and Yamika. So glad we could all get together today. So
it was a pleasure. Thank you so much, Dave. I really appreciate it. Ben and Yamika, thank you very, very much for allowing me to talk today.
All right. Thanks, everybody. See you this afternoon. Bye.